Brother Bill, thanks so much. Thanks for that thunderous ovation. I appreciate that. The judges are really more accustomed to kind of a mild kind of smattering of applause, so that was special. Thank you to TPPF, thank you to Bill for hosting us today in your magnificent new theater/cathedral. Thanks also to IJ, the Institute for Justice, and to the Liberty Institute for helping pull this event together. When I was a baby lawyer back in the 90s, before some of you were born, the most rewarding case that I ever handled wasn't the one that paid the most. It was actually the one that paid the least. And when I say the least, I mean the least. It was a pro bono case representing a mixed race Texas couple, one white, one Native American. And they were trying to adopt 2 African American boys. But they were being blocked by the state of Texas, which sort of had an unwritten kind of rogue policy of race matching. And there was no case I handled that came closer to offering greater satisfaction and greater fulfillment. A lot of cases paid infinitely more, but none was sort of richer in my experience. There are advocacy groups across the political spectrum, far left, far right, everybody in between, who increasingly sort of look to the courts to advance their agenda. And on the conservative and libertarian side, public interest law firms are finding increasing success in their effort to champion certain core constitutional liberties like private property rights or religious liberty, more recently economic liberty. Just a few weeks ago, a very wise and visionary jurist here in Texas wrote these words: Texans are doubly blessed, living under 2 constitutions, one federal, one state, sharing a singular purpose to secure individual freedom, the essential condition of human flourishing. People mistake majority rule as America's defining value, but our federal and state charters are not, contrary to popular belief. They are not about democracy, a word that appears in neither document, nor in the Declaration of Independence. Our enlightened 18th and 19th century founders, both federal and state, aimed higher. They upended things, and they brilliantly divided power to enshrine a promise, liberty, and not a mere process, democracy. Liberty is not provided by government. Liberty pre-exists government. It is not a gift from the sovereign. It is our natural birthright, fixed, innate, unalienable. We're going to divide this hour into 2 halves. The first 20 minutes or so, I'm going to quiz our all-star panel on some of the unique ethical issues that confront public interest litigators. And the rest of the hour, they're going to divide time and showcase the work of their respective organizations, and then maybe regale you with some recent war stories. But let's start by discussing client selection. Matt, on the far right from the audience's perspective, IJ's gotten a lot of accolades, really high marks for carefully vetting potential clients, for identifying people who will really put a sympathetic, compelling face on your litigation. So how does IJ go about identifying, obtaining clients, and what sort of ethical limitations do you face?
Well, thank you, Don, and thank you, Bill, for having us here today. It's very good to be here in this, as you said, beautiful building. We find clients in a very different way than most private law firms do. A lot of times they come to us, they say, I have a controversy, I need your help, can you take my case? And we take probably 10% of the cases that are presented to us, and each lawyer at IJ takes probably 2 to 3 cases per year. So we have a small docket, and we litigate that docket very aggressively and very hard. But usually when a client comes to us and says, can you help us, the case is not fully formed. The client has usually run into the government. They've told them they can't operate their business. They've told them they're taking their house. They told them they can't speak. And they know they have a problem, but they don't know what kind of help they need. And we, as a public interest law firm, litigate only constitutional issues. So the first thing we tell the client is, you may have a lot of claims that we can't litigate for you. You know, you may have statutory claims, you may have other kinds of claims. We're not going to litigate those. The only thing we're going to litigate are the public interest constitutional questions. And our goal as a public interest law firm is to overturn bad laws. We don't seek money in our cases. Clients aren't going to get money out of the case. Sometimes we'll sue for $1 in nominal damages because we have to for certain procedural reasons. But the only goal of the case is to overturn a bad law. And if the client is on board with all that, then typically we will work the case up internally and work with that client to find other people who have been similarly affected, so that we can present to the court and to present in the court of public opinion a group of individuals who is being confronted by an unjust law, who highlight both the law's injustice and the need for protection of individual liberties under the Constitution. You asked about ethical issues. One advantage you have as a public interest lawyer is you can actively solicit clients. I remember some friends of mine in private practice were horrified the first time I went to Dallas and was looking for clients for a case. I was having lunch with a friend and I told him, he said, what are you doing in town? You know, how are things going? And I said, well, I have a lady who's interested in suing the city, but we need more people on board. So I'm just walking into businesses here in Dallas and asking them if they'd like to join the case. And he said, you know, you can't do that. And I said, well, no, we can because we do it for free. And the Supreme Court actually said in a case called In Re Primus that we have a First Amendment right to do that. And it protects the right of public interest lawyers to actively solicit clients. In fact, we can actively solicit clients who are currently represented by a lawyer. We don't do that very often. It's actually pretty rare. That would be dirty pool. But having the ability to go out and seek clients is tremendously helpful in finding people to kind of round out our cases. So, you know, ethically, I think that's probably the biggest difference between being in private practice and being at the Institute for Justice is, as you said, client selection and how the cases get developed.
Jeff, what about you at Liberty Institute?
Yeah, I used to, we also, I think we're pretty aggressive in actually recruiting clients. I mean, one of the things that I get every day from my staff is a memo of everything that's been out in the media, in the internet world, where someone's religious liberty rights have been somehow attacked or infringed. And we look at those and just make it an internal decision. Is that something we want to go after? Because what we find is a lot of people just have no idea that they have religious liberty rights first. And the second thing they have no idea is that there are actually firms out there who are willing to represent them for free. And so part of that's education. Although I will tell you, after the Supreme Court's decision, I guess now about a month ago, in Oberfell, we had more calls on the day of the decision than we'd had the 3 months prior from people who were just completely wondering, how does this now impact me as a small business owner? How does this impact me as a pastor? So we are adapting, a staff in Dallas with about 35 employees, we're adapting to the phone ringing like crazy. I actually, and I like hearing your lawyers have 2 to 3. Please don't tell any of my lawyers that you guys only have 2 to 3 cases on their docket. Our lawyers have more. I've got probably right now on our docket 110 legal matters that we're working on in 20 states. And in order to do that, I've had to take myself out of the client selection process, because when someone calls me and tells me their story, I want to say yes. Mm-hmm. I really want to help, but you know, we have to be very like you guys at IJ, and we've got to be very strategic in what cases that we take. One, you've got to have a great factual case with good plaintiffs. The second thing is it's got to be a case that if you try and it goes through, it's going to be precedent setting, because we have limited resources. We have to really think through those cases. But it's been completely different than my 19 years in private practice. Right. And I was one of those guys. I remember when I first started and Kelly was telling me, well, go get them. I'm like, you can't do that. That violates the ethical rules. And he sent me that Supreme Court case, and ever since then, we go get them.
So Matt says they accept maybe about 10%. You know, the funnel's pretty narrow of potential clients. What about Liberty Institute?
Yeah, it's probably a little bit higher, but not much, maybe 15, 20%.
Okay. Rob?
Well, we're just getting off the ground here. I'm the director of the Center for the American Future, which is the litigation arm of the foundation here. For 26 years, the foundation has led Texas in a public policy advancing free market principles, but the recognition was given that so much of policy now that's being made is not being made in the legislative branch. It's being made in the executive agencies that are promulgating rules, largely without authority from a legislative body. And it's also being made in the judiciary, where you have courts that are enacting policies and making precedent that change the world. We've seen a lot of examples of those recently. Our focus is on federal litigation, really focused on advancing 10th Amendment principles and opposing judicial overreach and abuse at the federal government level. And so one thing that I would add to what Jeff has said, you said too, was in my approach, there's kind of an ethical consideration as well as to looking at the impact of what's going to be happening to your client from putting themselves into the fray in agreeing to be a plaintiff and suing the government. And I think it's not an exaggeration, but it's also a chilling thought that there is concern in some ways about how the government is going to react to you suing them. I mean, the government should not be retaliatory in any way, but there are examples out there, examples that are in the news of how you have groups and individuals that seem to be treated differently. In fact, a friend of mine who practices law here in Austin told me that he had a client that joined in a suit against the federal government, a client down in South Texas. The next day, they got audited and inspected, and they hadn't been inspected in 20 years. So it's something to keep in mind that there's over 300,000 criminally enforceable federal regulations on the books. And part of our job is to advance liberty, advance constitutional rights and the public interest, but we've also got to be mindful about who we're representing and make sure that we measure twice and cut once and really look at the implications of the law and have that end game in mind to make sure that we don't put our clients in a bad situation as the case moves down the road.
And just to follow up on that, I imagine there have to be times, whether your focus is economic liberty or religious liberty, whatever the niche of your organization is, there have to be times when your client's sort of objectives, there may be some tension between what your client seeks and what your organization, as a matter of precedent, and they just want to win, they want to be free to do whatever they want to do, but you're seeking, of course, a broader kind of high-octane precedent you can then sort of wield to greater effect long-term. So how do you deal with clashes, or how do you avoid clashes between client objectives and institutional objectives?
Well, you said avoid, and that's certainly the best way to deal with it. Those conflicts are something that we worry about a lot internally, and we talk about it a lot internally, because we're funded by donors, and those donors have, they believe in our mission, they believe in the work we do, and they want us to advance that work. But we're also attorneys, and our first obligation, ethically, is always to the client. And if ever there's a conflict between the organization and the client wins, because we're attorneys first and foremost. But you can avoid a lot of conflict in a number of ways. First, like I said, we don't seek money from the government, so the clients aren't in it for money. Sometimes it comes up in eminent domain cases, but usually there's not a monetary component, so simply buying someone out of a lawsuit isn't an option. That helps. Second, we talk about it with the client a lot before we sign them up. When we're signing the client agreement letter, when we're vetting the case, we say, look, they may come to you with an offer of settlement, and you need to understand that if you settle with them on an individual level, you don't affect everybody else who's being affected by this law. It just affects you. So please, are you willing to stand by us? Are you willing to do the right thing? And what we find is most of these people have been beaten around so much that they're just sick of it and they're in it to win it. It's very rare that a client will want to settle whenever the government comes with a settlement offer, unless that offer is we're going to repeal the law you've challenged, in which case it's a victory for the client. But as I said, fundamentally, if it comes down to it, these people are leading their lives. Especially our clients, they tend to be individuals, they tend to be small business owners, and whatever the matter of the case is, it tends to be right at the heart of their lives. They're not stockholders in a large corporation. They're not employees of a large corporation. It affects their business. It affects their home. It affects their individual speech. And so, some offers of settlement can be quite attractive. And on the margins, if the client needs to take that offer in order to get on with their lives or keep their business open, then that's what we're going to do. But as you said, Justice Willett, you anticipate that on the front end by signing up certain clients and by coming to an understanding with them at the time you're signing them up, not talking about it to them later once the offer's on the table.
Yeah. I mean, really good engagement letters.
Yeah.
I mean, we actually spend some time in going over it with clients. We think that's important because I think they need to know, as Matt said, who our organization is. They need to know that we're not charging you for our legal services. And as a result, you need to understand that we do have to, for instance, raise money, and raising money may include on your cases, and you need to be good with that. And that brings up Rob's point, and that's going to put you in the media eye, and certainly on the issues that we work on. The mainstream media does not like most of our issues, most of our clients, and so you might be attacked on whether it be your local news or even on the national news or whatever. So we need to do a lot on the front end. I think like you, Matt, we work really hard on the front end to avoid those conflicts. And Matt's right. If eventually it drops and you feel like the organization's objectives are coming at odds with the clients, the first thing is to try to work it out. And in my 5 years, we've been able to do that in each case. But at the end, we are lawyers, and if there's a disagreement, the client's going to win. And whether that means we'd have to drop the case and/or we'd drop the organization's goals. Fortunately, that I think it helps in client selection at the out front. Everybody understands that we're on the same team. And I think that's been, to me, in my 5 years, the most rewarding thing has been, it's like the case you talked about in your introduction, Justice Willett. It's representing these real people who are really, the lawyers sometimes get the accolades. We get to argue the cases. We get to have that kind of the fun. But these clients whose lives get to change, they're being told by a government they can't do something. That's something in our case, something very near and personal to them, exercising their religious beliefs. And then you're able to have a pastor who's told he can't pray because it's on public land, and then he gets to give that, and you feel the appreciation. I mean, these clients are wonderful, and they're the real heroes, and it's always an honor to represent them.
And I think from a pragmatic standpoint, too, that one of the ways to address that helps make your case successful is looking for diversification. It's a stronger case to have more than one plaintiff that you're representing on that issue, but if they're all cookie-cutter plaintiffs that look exactly the same, then you run the risk that you could be cleaned out on a procedural matter or standing or a substantive matter. But just as you want to have that personal relationship with your clients, in some ways you want them to come at the issue that you're attacking from different ways. And so if you have a client that wants to settle, that wants to quit the lawsuit, or gets dismissed from the court, then your whole case doesn't fall apart. I mean, most of my career has been on the defensive side. I started out working in the general litigation division for the Attorney General's office, where I'd represent Texas when Texas would get sued. And in a way, when Texas would get sued and I would be assigned the case, in some ways I thought about that as just, trying to hack at the legs supporting the stool. You just start taking out issues and you start taking out plaintiffs, and eventually the case would fall. And so now that I'm on the other end and I'm advancing liberty cases, I want to build the 12-legged stool so that one piece falls apart and the case can still advance and we can still pursue the goals that we have there.
I want to give each of our panelists time to sort of showcase the work of their respective group and maybe give them each about 10 minutes to kind of just describe their organization and maybe give a recent kind of snapshot of the kind of work they're involved in, maybe a recent kind of war story or two. So Jeff, why don't you begin?
Sure. Again, Jeff Matera, I'm General Counsel at Liberty Institute. As Bill mentioned, I started there about almost 5.5 years ago. Of all things, Judge, I thought I wanted to be a judge. And I met, probably you did way back when too, I met with my friend Kelly Shackelford and expressed that interest, that I was thinking about doing that. Unbeknownst to me, Kelly and God had some different plans, because Kelly started asking me weird questions like, can you afford to make what a judge makes? I didn't realize
That's an important question.
He was, and probably no one surprised in this room, judges make less than lawyers, than partners at law firms in Dallas, for instance. And so Kelly asked me that. What I didn't know is Kelly was setting my salary for what eventually became my job. But Kelly then asked me the key question. He said, now you've really enjoyed working on religious liberty cases, haven't you? Because I'd volunteered with Liberty Institute when I was in private practice. And oh, Kelly, I love it. And he said, well, as a district court judge in Dallas, how many religious liberty cases do you think you'd work on a year? And of course, the answer then was none. That may not be the answer today, 5 years later. And he said, well, how would you like to work on religious liberty cases every day? And after telling him because I'm very spiritual, I said I had to pray about it. I went out to my car, called my wife, because we were anxious about leaving private practice financially. Could we do it? The governor was about to appoint a vacancy. We thought maybe Kelly had some inside information. So I call her. I said, you're not going to believe this. He offered me a job to be his general counsel. He wants to expand out of Texas, build a team engaged in religious liberty work. And my lovely wife, who's a wonderful woman, said, she said, well, what did you ask Kelly? And I had to tell Kelly. And I said, well, I needed to pray and talk to you about it. So I'm not so sure I said that to Kelly, but certainly for the phone call, I was going to say that to my wife. And she said, well, what did you say? And I said, well, I need to talk to you and pray about it. And she said, you're an idiot. He just offered you your dream job. Why did you go to law school then 19 years ago? And that's how I kind of feel. I 5.5 years later, to get to do what I get to do every day, defending people's religious liberty, to get to work with veterans and pastors and people of faith who are under attack. And we can open up the Austin American-Statesman this morning, and you can see attacks on religious liberty. At no time in our country have people of faith been under attack. We do a survey at Liberty Institute in which we try to catalog all the instances of where people's religious liberty rights have been threatened. We started that 3 years ago. We finished the 3rd edition last year. We're now working on the 4th edition. In 2 years, the instances of hostility have grown 133%. And I remember I was in the office the other day and I get this phone call and the receptionist sends to me, this man is irate. And I was trying to figure out why is he so angry? He was from Ohio and he's telling him about this situation and I'm trying to think, did we decline his case? Why is he, I'm thinking, why did she put him through? Why am I talking to him? But in the midst of it, what I figured out is he had gotten our survey and his case wasn't in there. And he was mad at us for not listing his case in our survey. And all I want to say is that 133%, I don't think we have every case. But we're attempting to catalog because we know the left is saying, oh, this really isn't an issue. You're just overinflating it. So what I did is I took one of my staff attorneys who's a Harvard JD, and I put him, he's editor-in-chief, and his job is, if we have it in there and listed, we can prove it. And so when people say, we don't think this happened, oh, no, here it is, here's the pleading, here's the court order, here's the reference for this, because everything is footnoted and documented. The end result is 5 years after I've joined Liberty, we're now the largest legal organization that's dedicated exclusively defending religious liberty in America. And we've gone from what was primarily a Texas group working just in Texas to today, as I mentioned, I think I've got 110 legal matters on my docket in 20 states. We represent veterans organizations who are defending their veterans memorials simply because they contain religious imagery. We represent churches and faith-based ministries who, today are more so under attack than any time in our nation's history. Students and teachers who are seeking to exercise their constitutional rights in public schools. And we even come alongside state and local governments who are being threatened because of so-called Establishment Clause violations. Important to know we represent people of all faiths. We represent Jewish folks and Muslims and Christians in all matters. Really, our view is if you threaten religious liberty against anyone, you're threatening against all. And so it's important to defend every time someone's religious liberty rights are being threatened. I mean, our motto is to protect people not only to believe, but also to be able to act on those beliefs. We think that's very consistent with what the founders envisioned, and truly believe that if you take away religious liberty, then all freedoms will fail. If you take away religious liberty, then economic freedoms fail. We think you just look at world history and see that. When there are dictators take over, whether they're communist or fascist, the first thing they attack are people of faith. And then everything else falls. And so that's why we think we're on the front lines of really the battle for liberty, because religious freedom is so important. And one thing's different than us and other groups, we use volunteer attorneys. And we go out of our way to associate with some of the top lawyers in the country. And so when we get a case in Montana, our team will be a volunteer attorney who practices in Montana. We get a case in Bladensburg, Maryland, outside D.C. We're going to get a Washington, D.C. firm like Jones Day, and then we're going to employ the best team, because we use the approach that I used for 19 years in private practice, which is the same approach corporate America uses. We look for the best lawyers in the country, we associate with them, we let them be lead, and what's great is strategically, almost like there's an invisible hand out there, there are men and women in large, small law firms who are dedicated to working on liberty. One of our cases I wanted to briefly share about is, and it was played at the beginning, involves a Jewish synagogue in Dallas. And it's the case of Congregation Taurus IM. And to me, it's just an example of how bad it's gotten out there. But this group of 20 or so families live in North Dallas, and they're Orthodox Jews, which means they walk to Sabbath on Saturday mornings. So they need to have a place to worship in their neighborhood. They chose a nice neighborhood in Dallas. They'd been meeting there for some time, and then one of their neighbors started complaining. Well, not only did he complain, but he filed a lawsuit against them, saying they're violating their homeowners association. Not only did he file a lawsuit, he then ran for president of the homeowners association and took over that and added the homeowners association to the lawsuit. Now, to make a long story very short, we were successful in defending that lawsuit in Collin County and getting summary judgment on behalf of the Jewish synagogue using federal and state law. And we had a great victory, and if you see the video is the celebration of that victory. But within weeks of that victory, the city of Dallas came knocking. No city of Dallas officials, I assume, in the room today, so I can talk about this. They filed a lawsuit saying that this Jewish congregation who's meeting in a private home violates city of Dallas ordinances because three primary things. One, you need to have a separate front entrance. So in your house, because you're meeting, you're having a weekly meeting, you have to have a separate front entrance. Also, you need to have 13 parking spaces in your back. Remember, this is the Jewish congregation where they walk to Sabbath. Logic and the city of Dallas never go hand in hand. And I know this is being recorded, Rob, but it's okay. And then the third thing is, because you're meeting there with a group of 20 people, you need to build firewalls, all to the tune of about $200,000 in this $300,000 house. So we're defending them. We're using a law, I believe, Justice Willett, you were involved in. I know you're involved in as a jurist. You wrote an opinion. I think when you were in the state you're involved in, the Religious Freedom Restoration Act. Texas does have one. They're very important. And what they say is, look, just because you have religious exercise doesn't mean you always win. But if the government is substantially burdening your religious exercise, like meeting in a private home, then the government has to come forward with a compelling interest and has to show that the only way to fulfill that interest is through the means it's seeking. So in this case, we're battling using RFRA because it is important, and we're blessed in Texas to have a strong RFRA. All the states need RFRA. So that's one example, gives you a flavor. I look forward, if you have questions, talking upstairs when we're in the reception.
Thank you. Hey Matt, talk about IJ, what you've been up to. You, of course, lead the Texas chapter. In Texas, for all of the Lone Star State's vaunted sort of commitment to economic dynamism and welcoming entrepreneurs, there's no shortage of matters on your docket as well. So why don't you talk about IJ and what you're up to and what you're focused on?
Sure. No, there are certainly no shortage of cases. In fact, we have some new cases coming up soon. But it was interesting to hear you talk about the city of Dallas. We sued the city of Dallas a while ago. It was over a sign ordinance. And I remember I was speaking at a barbecue place for the Republican Club of Dallas. Just, this is IJ, this is what we do. And the mayor's wife was there. So I forgot to pre-screen the room before I started talking. And I remember I finished my little spiel and I stood up and she stood up and she had a question. She said, I just want you to know it is costing the city of Dallas a lot of money to defend this lawsuit. And I just felt like saying, oh, I'm sorry, well then I won't sue you. I mean, the city's lawyers.
I would have said amen.
Yeah, I mean, the city's lawyers were working for a salary, presumably, like I am. They need work. They have a very large legal division in Dallas, but it was almost like it was a personal affront to the city that we had sued them. And one thing about our suits, they're not personal. It's very rare that we're alleging malfeasance or misfeasance by a public official. It's very rare that we name a public official personally. Our suits are designed to change bad laws, and in a way they're a gentleman's disagreement with the government about the proper boundaries of individual liberty and governmental power. For IJ in particular, I guess I'll tell my origin story a little bit since we're doing that. I was at a big law firm named Hughes & Luce in Dallas before I went and did this. And probably like you, I took a fairly substantial haircut to come down here and do it. But it really is one of the best jobs you can have. IJ was opening the chapter, now we call it an office, in Texas at the time. I was lucky enough to convince them to let me run it. We have offices in 4 other states. We're in Florida, we're in Arizona, Minnesota, and Washington State. We have a legal clinic at the University of Chicago Law School, and we're based in Arlington, Virginia. We have about 32 attorneys and about 80 staff members total. And unlike you, we litigate all of our own cases. We don't bring in outside counsel very often. If it's an IJ case, it's an IJ case, and it has been vetted by our litigation team. It has been approved by our board of directors, and it has usually taken 2 or 3 months to work up. We have a very long gestation process for our cases. But the goal is always the same, and that is to advance liberty. And we work in 4 areas. We call them our 4 pillars. We work in free speech, primarily on behalf of individual businesses for commercial speech or for occupational speech. We do campaign finance work. We work in property rights. We litigated Kelo versus New London, and we have pushed for change in eminent domain laws across the country since we lost that case back in 2005. And something like 44 or 45 states have reformed their eminent domain laws since Kelo, so we turned a defeat into a victory. We defend school choice programs whenever states pass them, so we're hoping Texas will give us a school choice program to defend maybe next session. I know TPPF's working on that issue as well. And then we also work in an area called economic liberty, which is the right to engage in the occupation or the business of your choice, free from unreasonable government interference. And what that means, in our view, is not that the business owner or the property owner always wins, but it's also not that the government always wins. Government can enact economic regulations as part of its police power. They have the power to protect people. They have the power to protect the public and the common good. But there are limits on that power, and the Constitution, both Texas and federal, prescribe limits on that power. And the one thing that we always emphasize in our cases is, if you're going to take away someone's economic liberty, if you're going to make them get a license before they can do something, if you're going to restrict how they can operate a business in a certain way, you just have to have evidence that it is necessary to protect the public good. That's all. You can't just pass laws willy-nilly. You can't pass laws just because some special interest group asked you to pass a law. We work a lot in the area of occupational licensing. And one thing that I learned once I started working for IJ is occupational licenses are not created because the government identifies a problem and then thinks hard about how it needs to regulate that occupation to protect people. Occupational licenses are created because someone runs to the Capitol and says, please, please, please regulate me and stop that guy from doing what I'm doing. And here's a couple of kind of crazy anecdotes for why you need to allow me to do this and not that guy. Oh, and by the way, everybody who does it right now should be grandfathered in. So new entrants to the market have to jump through whatever hoops we establish in order to enter the market. And a recent case that we had, a recent victory that we had in federal court, I think highlights that very well. As you saw up on the screen, I think, we represented an African hair braider named Isis Brantley. And Isis practices in Dallas. She's actually pretty famous in the hair braiding world. And like all African hair braiders, Isis just braids hair using her hands. She doesn't use chemicals, she doesn't use dyes, she doesn't use blades. She just braids human hair. But the state of Texas told Isis that if she wanted to teach other people how to braid hair at her salon, and her salon has 3 chairs, it's in South Dallas, it's a small little salon, she had to open a beauty school, a cosmetology school. She had to install 2,000 square feet, she had to install 10 workstations, and she had to install 5 sinks. Even if she just wanted to teach one student at a time, she had to spend $40,000, $50,000, $80,000 building a cosmetology school before she could teach someone the ancient art of braiding African hair. Now, why would we impose those rules on Isis? It's not to protect anybody. She could have a student in her salon sitting in the chair. It's a licensed salon. It has a certificate of occupancy from the city of Dallas. It's inspected by health inspectors, one at a time, without complying with any of those requirements. But the state of Texas had those rules to protect beauty schools because it makes it expensive to open a cosmetology school. And so beauty schools and cosmetology schools went to the legislature, they still go to the legislature, and they have those rules put in place to protect themselves from competition. But protecting people from competition is not a legitimate government interest. You can only exercise the police power to actually protect people. And so we took that case to federal court. Judge Sparks agreed with us, and he struck down all of those requirements. And so now, Isis Brantley operates her hair braiding school out of her salon as she always wanted to, and she's free to do that. And those are the kinds of cases that we bring. They're small business owners, they're homeowners, they're parents, they're children, but they're people who are being, having their liberty burdened by the government and who have constitutional rights that we help them exercise that they would not otherwise be able to exercise. I see you're calling time, so I better turn this over to Rob.
Rob, talk about the Center for the American Future and what you're up to.
Certainly, and first of all, again, everyone welcome here to the Texas Public Policy Foundation. We have a few new faces to the foundation, so I'd like to visit just a little bit about who we are and first of all, where you are. You're in the headquarters of the Texas Public Policy Foundation. This is a new building that we opened in March of this year. We had our grand opening in April. And the purpose of this building is not to have us office space. We had office space before. We're a 501c3 nonprofit organization and cut every cost that we can in order to pursue our mission. But the vision that our CEO, Brooke Rollins, had in leading forward that led to this building was about the symbol that this building would represent. That if you look around Austin, if you look around other capitals, you have all of these special interest groups that are represented, physically represented in proximity to the government. And here in Austin, there's no exception. You have trade associations, you have special interest groups that have their buildings all around here downtown. And at the time that the foundation existed, there was no location for where liberty was. There was no location for where the free market conservative principles that we espouse were physically located as a symbol. And so this building was constructed as a symbol to be the headquarters for liberty, so that we would have the opportunity, we would have the space to have this kind of dialogue and this kind of discussion and talking about the important liberty principles for which we exist, that we can now point to 901 Congress here in Austin, Texas as the headquarters for liberty. The foundation has been around for 26 years, and its goal has been to advance free market principles. Originally, we started off 26 years ago. I think there were 3 or 4 employees with the foundation. The foundation was originally began to advocate for tort reform and school choice. And as we've grown over the years, we've grown to expand, and we have several policy centers that advocate for conservative principles, from low taxes to low government regulation to criminal justice reform from a conservative perspective to economic freedom to education freedom to healthcare policy. But the realization was made last year that so many of these policy issues were being made outside of the legislative branch. And so the basis specifically was looking at the concern that was coming from some of the federal regulations that were being made that threaten us here in Texas by their implications. And so the Center for the American Future, which I'm the director of, was created to advance 10th Amendment principles through judicial opposition to federal overreach and abuse in the subject matter areas of environmental, private property, and business autonomy rights. And why I'm so passionate about being here, why I'm giving my career here to this foundation, is because I'm a father. I've got a 5-year-old and I've got a 3-year-old, both boys, and it's true what they say, the definition of boy is noise with dirt on it. And I want the best for my kids. And honestly, I'm concerned about what their future looks like. But more than that, I am angry that I have to have that concern. That the guarantee of America has always been that your children and your grandchildren would be better off than you are. And I think in today's world, we have to pause and we have to question whether that guarantee still exists. So my mandate as the director for the Center for the American Future is to get into the fight. When I was hired, one of our board members told me, he said, "Henneke, I am tired of being on defense. You're here to get on offense, to get into court, to push back against federal regulatory abuse, and to win these cases in pushing back against the past 100 years of jurisprudence that slowly eroded our constitutional rights." And sadly, for today's time in America, there's no lack of example to do so. On Monday, we expect the Obama administration's Environmental Protection Agency to publish what's called the Clean Power Plan, which is the effort by the administration to implement the cap-and-trade legislation that Congress rejected in 2010. And what it's aimed to do is to reduce energy generated by fossil fuels, to close coal-fired power plants and to close natural gas power plants, and theoretically replace that with renewable energy. And I have no problem with renewable energy. I think in a free market world, all of the different sources of energy can be able to compete and thrive. But the implications of the Clean Power Plan is that your electricity rates here in Texas are projected to go up by 20 to 30% here in the next 10 years as a result of the Clean Power Plant. That's going to disproportionately impact low-income families who have more of their household income that goes to pay their utilities and their overhead. You had recently the EPA redefine the definition of waters of the United States under the Clean Water Act to give them almost unlimited jurisdiction over any kind of water in the United States. You know, that puddle, that ditch in your backyard that every time it rains in Texas, whenever that is, collects water. You know, that arguably would be a federal wetland, that the federal government could come in and tell you what to do with your private property rights. And so my mandate is to develop cases here that advance liberty, that represent Texans and Texas businesses that are threatened with federal oppression, but also to find ways to challenge federal regulations and to not just, put government back into the box, but to make that box smaller and getting back to the founding principles that the Founding Fathers established with the Constitution that we live under here in America. So one of those federal regulations that I'm very concerned at involves the Endangered Species Act. And the Endangered Species Act, was adopted in the 70s to protect species that were threatened with extinction. But in the language of the Endangered Species Act, the goal of the ESA is recovery. The goal is to bring species back to the point that they don't need to be protected by federal regulations, that we can hand that back over to private property owners and have respect for private property ownership. But what's happened is that the Endangered Species Act has been turned into a weapon of environmental groups who have used it not to protect endangered species, but a way of attacking businesses and controlling development or opposing development. And so these species have been listed and these efforts have been led to species that shouldn't be on the list or at some point should be taken off the list. Just 3 weeks ago, I'm part of an effort with here with the foundation with a group called the Texans for Positive Economic Policy and also the Reason Foundation, and we filed a petition with the Fish and Wildlife Service to remove the golden cheek warbler from the Endangered Species Act list. And I think this is a success for conservation because there was a study that was commissioned by a department at Texas A&M University that published their study this year that identified that the golden cheek warbler, which is a migratory songbird that breeds here in Texas, that there are 19 times more of these birds here in Texas than were estimated at the time that the species was listed for protection 25 years ago. And not only are there 19 times more of these birds, but this independent A&M study calculates that the habitat for these birds is 5 times greater than it was back in 1990 when the listing of the warbler was rushed through on an emergency basis and was done so using data from 1980 and studies from the 1970s to justify that. So what we've done, I think it's a victory for conservation, and what we've done is we've asserted an effort to bring this current science to the Fish and Wildlife Service to hopefully remove the federal regulatory burdens that are imposed in connection with the Endangered Species Act, because ESA protection for the warbler can be scientifically demonstrated to not be needed anymore. You know, just for example, if you live in Williamson County and you want to do something with your land that would cause a take, and that's ESA slang for a potential impact upon the species, you have to get a take mitigation permit to do so. And the cost to do so, if you have property of less than 200 acres, is approximately $7,000 per acre to get an ESA take permit in order to develop your land or do something with your property that would be prohibited by the ESA. And so if there's a purpose for protecting an endangered or threatened species, then let's protect them. But when we brought those species back to recovery, then we don't need to have regulation just for the sake of regulation. The one case I want to highlight has been a success story that's come out of Utah. Is actually a coalition that the plaintiffs were called the People for the Ethical Treatment of Property Owners. And what they did is they sued the Fish and Wildlife over the regulation of the Utah prairie dog. And the Utah prairie dog is an intrastate species. It's a species that only exists within the southwest corner of Utah. And what the plaintiffs did in that case is that they asserted that there was no substantial relationship to commerce that Utah prairie dog had because it existed only within the state of Utah, and therefore there was not a constitutional basis to regulate that species under the Endangered Species Act. Because keep in mind, you know, the powers that Congress has in adopting these regulations are theoretically supposed to come from the framework of the United States Congress, or Constitution. And so it was a success. You know, there was arguments that even though the plaintiffs in that case had nothing to do with interstate commerce, well, someone else might have to do with interstate commerce, and so everything should be regulated. And that was rejected, and also was rejected an argument that while the Utah prairie dog wasn't an interstate commerce species, the whole necessary and proper basis for the Endangered Species Act calls for just regulating all of these species altogether in one sum total. So the point is that there's some victories being had in pushing back against this federal regulatory overreach and abuse. And my goal is to bring that here into Texas and advancing these cases here and providing for our children and our grandchildren's future and bringing more liberty here to the headquarters for liberty. Thank you, Don.
Thank you. I think we all know a lot of lawyers, obviously, and we know a lot of disenchanted lawyers. None of them are on this stage. And you guys have really cracked the code. You kind of understand that it is a magic combination to really love what you do and believe that it really matters, that it really counts in a grand, big picture, multi-generational sort of way. And what really matters more than liberty really is the essential condition of human flourishing, in my view. Ben Franklin once reportedly said, maybe not assuredly, but reportedly said that the democracy is two wolves and a lamb voting on what to have for lunch. But liberty is a well-armed lamb contesting the vote. And these three guys, these three shepherds, I guess, are obviously packing some serious legal heat as well. And please thank our terrific panel. We're going to have no Q&A time here, but I think as Bill will explain in our reception after this, will all be available. You can kind of pepper them with whatever rapid fire or impertinent questions you might come up with. So thank them all for me. Thanks.